And it's now again, you can Excel or reduce that, and just do the. And good to go.
We'll start again, a little bit later than it was. Our first order of business, our chair is not present, and we need to chair for the meeting.
Move to elect Bobby Bach.
Second.
Discussion. All those in favor?
Aye.
We then need to determine that we have a quorum, and to have that quorum, we would like to, our associate members of the zoning board, Justin and Patricia, I'd like to move that they become members. That is a motion. Is there a second?
Yes.
Discussion. All in favor?
Aye.
And we do have a quorum. Overview of the case. On July the 5th, the building use application and a site plan review application submitted by the library. On the 12th of September, the planning board approved that submission contingent upon a certificate from the Historic Preservation Commission. On the 15th of October, the Historic Preservation Commission denied that application. On the 13th of November, the library filed an application for an administrative appeal. That application was for a native garden, including that the original application was for a native garden, including a 2-foot granite wall, brick walkway and handicap ramp, brick patio, bike repair station, and a new book drive. That is the case. Do we feel that we have jurisdiction in this case? Yes. We must vote. We do. I will view that we do have jurisdiction in this case.
Second.
Discussion. All in favor? Second thing is, does the appellant have standing? Need a motion to that effect also.
I move that the appellant has standing.
Second.
Second.
Discussion. Favor? This is going to be a de novo hearing, not an appellant hearing. We will begin tonight. We have several interested parties, but begin with the library making a presentation of why they have applied, made the application for this hearing. Please.
We believe that there has been an error in the decision to deny the application, denies the certificate. Sorry, I'm not the best at public speaking, so please bear with me. That decision was decided dependent on Article 12.2.1 says, except as specified in Article 9, a structure designated as a historic landmark or site of a structure located in a designated historic district or related structure improvements, walls, fence, light fixtures, steps, or paving located in a designated historic district shall not be altered, and no historic preservation certificate shall be issued for such actions unless these actions will preserve or enhance the historical and architectural character of the structure. We do believe that it will enhance, but this specific section also says, except as specified in Article 9. And in Article 9.3, it says lawn and garden objects and landscaping, including plantings, sculptures, walkways, and walls of 2 feet or less in height, do not require a historic preservation certificate. Much of the discussion at that Historic Preservation Commission meeting was about the wall, which in every iteration of the drawings that we have presented to planning board, HPC, and you tonight, that has been designated as 2 feet tall, which the CEO has made it clear that he will be measuring when it's in to make sure that it is 2 feet tall or less, which we will gladly accept. it also mentions walkways, which I know elsewhere in the ordinance, it does say that the Historic Preservation Commission has jurisdiction over raised walkways. However, with the slope of the hill, our walkway actually ends up being more of a recessed walkway. And I know that recess doesn't appear in the language of that. However, 9.3 does say that walkways do not, specifically garden walkways, do not require preservation certificates. Otherwise, they were looking at patios, which are not specifically spelled out in 9.3, but we would argue that our patios are landscaping. And really, the only thing that's denying allowing us to put those patios in is only allowing the public to interact and experience the garden to its full extent. We also believe that the patios and the walkways, which will be made of red brick, will make the library property more consistent with the surrounding properties and other properties within the historic districts. As there are brick walkways at Stephanie Young's property, at the Historical Society, at the Universalist Church, at the Emerson Hall. You all walked over it on your way in here, and at the Days house next door in their garden. And that's just a small selection of properties that also have brick walkways and patios. I also say that there are also a number of properties within the historic district that also have granite walls. We actually showed our stonemason and our landscape designer what is now the Stommans garden and the granite wall in there as reference for how they designed our.
Other parts of the presentation that you'd like to make? Question?
I think that's a question to the CEO. Do we have a definition of raised walkway?
That was drawn up for just that purpose, right? That you do is while you're looking, maybe I can, and I don't mean to make you talk and be uncomfortable, but I suppose you referred to the Historic Preservation Commission to begin with.
There are portions of the plan that members of the planning board and the CEO thought might fall under the Historic Preservation Commission that I hadn't previously thought. I think it was the CEO's intent that we just make sure that we are following all the steps that we need to. So I asked him, so it was a matter of process, not that things had been identified that seemed to fall outside what was allowed by the viewer. Yes.
To answer Mark's question, no, there's no definition in the historic preservation ordinance on raised walkways. But I can opine on the submission we'd like to.
Please.
So as we've talked, 7.6 and 9.3 of the ordinance conflict. on non-contributing properties, landscaping projects and raised walkways, and many of the things that we're talking about tonight are not in the Historic Preservation Commission purview. On contributing properties, however, there is a distinction in the Historic Preservation Ordinance that says that raised walkways are within the purview. The wall was not on the application, was not part of the purview because the applicant stated that it was going to be under 2 feet height. However, because it was designated as a contributing property by the Historic Preservation Commission, that became the raised walkway, became raised walkways and patios became part of their purview.
But we don't actually have that. But we don't have a
For that. We, in our ordinance, we have in our bylaws, we can hear from other interested parties. There are interested parties who would identify themselves. They would stand up and speak. Yes. Sorry to be formal. Thank you.
Mark Pelletier, Chair of the Historic Preservation Commission. I'm joined here by 2 other members of the commission. And I am how far back I should go, but I'm going to take a moment and explain how the Castine Historic Preservation Commission presents to it, if I may. Yes.
If it's pertinent, what was just presented,
Well, in that case, I won't, but I will respond to the written appeal, which I think you all have, from Memorial Library. Now I'll respond to various paragraphs within it.
Is this exhibit 1?
It's got a written number 1 on the form. Letter of appeal of the Castine Historical Preservation Commission rejection of certificate for the proposed landscaping at the Little League Memorial Library. That's the title. You all got it?
and we've read it, so
Good. Then I can respond to some relative points made in this. Number 1, in paragraph 2, there's a reference to reducing water usage. Since there is no water irrigation on the property, there is no water usage at all.
sorry, Mark, if it's pertinent to what your responsibilities are in the Historic Preservation Commission, I don't see anything about water preservation, so that's really interesting, but let's move to something in your purview.
And if I may, I'd like to state that there are a number of assertions made in the appeal that have nothing to do with the Historic Preservation Commission's actions, number 1, or the planning board's actions. Second, this has to do with process. Paragraph 3, Sean Blodgett supposedly noted in his transmission of the decision to deny. There are no findings of fact. In fact, I specifically wrote, pursuant to 12.2.1 of the Castine Historic Preservation Ordinance, application is denied. Also, at no point did Blodgett ever mention to me what I wrote is insufficient or non-existent. That's germane to this decision. I would also like to note that prior to the planning board having heard this application, the Castine Historic Preservation Commission was have been the first to be applied, not the second. And in fact, the planning board approved the project pursuant to approval by the Castine Historic Preservation Commission. And the Castine Historic Preservation Commission heard this application first. And if it had denied it, I suspect that the planning board would have looked at the project a lot differently. Because in fact, the planning board was asked to look at it because there was a report, the reason for it was because there was movement
Let's stick to the appeal.
as part of the appeal. The planning board was asked to look at the project because there was a certain amount of land that was going to be moved. I think the number was 60 yards. In fact, there was no way for anybody to know how much property was to be moved because there was never a plan that indicated such. Therefore, the planning board never should have heard this application in the first place. Second, a lot of what I have here refers to what the appeal language addresses. Section 12.2.1 refers to sites and structures located in the historic district. And Mr. Barry has just noted. It says that sites and structures shall not be altered, and no historic preservation certificate shall be issued unless these actions will preserve or enhance the architectural and historic character, etc. I'd like to state that the original meeting I ever had with the library board director and the executive director, which I was invited to in May of 2024, I was shown a plan. And at that time,
That was not part of what you just reviewed. Could you stick, please? I'm trying to stick.
I'm trying, but they're, all right,
Maybe for everyone, the reason for that is that the board can only consider facts directly relevant to the appeal. So it's really just that's what we need.
but there are a number of assertions that were just made by Mr. Barry about patios and walkways, etc., which are counter to the plan and counter to what is actually factual in the surrounding properties. For instance, there are no patios on the common. There are brick walkways. There are no patios. So for him to state that there are patios is incorrect. Lastly, I want to note something. On March 5th, 1906, George Witherley, in consideration of $1, conveyed a certain property to the quote inhabitants of said town of Castine and the said county of Hancock. Further stated as said inhabitants and their successors. The property. I suggest the property in question in the appeal belongs to the inhabitants and their successors, and therefore the library does not own the land and may not be actual owners of the site. Therefore, they may not have any legal standing to take on this project or to make an appeal. And I am ready to answer any other questions or rebut anything else. Thank you.
I must say, I don't know what your reference to the CEO was, but we were given what came from the Historic Preservation Commission, and courts usually have finding of facts. Then they have votes, who voted what for what. There's no finding of facts in the minutes of the meeting, so we're working with no facts.
The application states specifically, reference 12.2.1, that we denied. That was a finding of fact. And I delivered it to Sean Blodgett, and he never said to me once, oh, by the way, you need to include such and such and such and such. Not a word. But he obviously went to the library board and told them that I didn't include the finding of fact.
The CEO is not on trial by this meeting, so
I'm not suggesting that it is.
I just would tell you that I labored through this and I was hard pressed to get from a reference to a section and the basis under the Historic Preservation Commission ordinance. Get from there to the decision. I read it and reread it, and I'm asking for some facts.
What fact would you like to know?
Well, 12.2, whatever. What is it? What are the facts that the Historic Preservation Commission found that violate?
It's all about the viewscape. Entirely about the viewscape.
Yeah, viewscape, maybe, viewscape, you mean just, we all
As
have.
defined in the ordinance,
Uh-huh.
it states, I'll read it.
I've read it.
Okay, so you don't want me to read it into the record.
Sure, you can read it into the record, that'd be fine.
Article 12, reconstruction, renovation, and alteration, 12.2.1. Except as specified in Article 9, a structure designated as an historic landmark or site or a structure located in a designated historic district or related structures or improvements such as walls, fence, light fixtures, steps, or paving located in a designated historic shall not be altered, and no historic preservation certificate shall be issued for such actions unless these actions will preserve and or enhance the historical and architectural character of the structure and are visually compatible with the viewscape. We did not believe that the addition of a stone wall on the town common, on into the town common, would preserve or enhance historic or architectural character.
So like,
Go ahead.
So I'm sorry, I'm a little slow, but viewscape is a very broad word, and I guess it's subject to an individual interpretation. Which way were you looking? Which viewscape was it that you think what being proposed countermands, goes against the historic nature?
Well, it's the view up Port Street, it's the view down School Street, it's the view from Green Street. You know, there's a stone wall proposed on 3 sides of the site, essentially creating a plinth that separates the library property from the rest of the common.
A stone wall, which by the way, isn't subject to review because it's less than 2 feet.
And as I started to state earlier, the first time I met with Mr. Berry and Ms. Lyons, pointed out that there were 5 steps, 5 rises going to the site. I said, that makes it a 3-foot wall. They looked at me like, oh. Then they went back and they wrote 2 feet. And they removed 1 step. At each step of the way, there's been a reduction in the amount of work that needs to be done in order to try to satisfy both the zoning ordinance and the historic preservation ordinance in reaction to guidance and or points that were made to them.
Okay, so you pointed out, and I'm sure they would agree with the board that it was
Okay.
within violation. And so it was reduced to 2 feet, which makes it not subject to review. So why is that an issue? Why is a 2-foot wall an issue if it's not subject to review?
Well, first off, to this date, there's not a single document presented by the library that shows specifically that the walls will be 2 feet high. They may be 2.5 feet high, and there's nothing on those drawings, engineered drawings, that indicate precisely what will be built. To this date, there is.
yes, so when I think about the finding of fact question, I would want to understand how the board decided that Article 9 doesn't apply here. Could we establish that the walkway is raised, or did the library concede that the walkway is over? Did the board establish that the walkway is raised, or that?
It is indeed raised. It goes to a platform that's probably close to 3 feet above Court Street. That's why they want to build a 2-foot high wall, so that they can ascend up to a viewing platform that is approximately, I don't know, I don't have engineered drawings. I can't tell you if it's 31 inches or 33 inches or 38 inches. There's no way to know. And there never has been any way to know how tall that raised walkway, including railings and a stairway to access.
Sorry, Brock, we do one interested party at a time. Sean, I've got all kinds of things that show a 2-foot wall. Have I been misreading?
No, when the planning board looked at this, move back up just a bit, the planning board actually reviewed this. 60 cubic yards does not require planning board review. 60 cubic yards where you're changing the grade by more than 6 inches does. So that's why the planning board saw it. There is no precedent, there's a precedent, excuse me, there is precedent that the planning board is the last stop before permit is issued. But there's nothing in writing. Scheduling and putting cats into a room of all the planning board members and all the Historic Preservation Commission members dictated that planning board actually went first. So they chose to approve this project contingent upon Historic Preservation Commission certificate. So it was simply a scheduling thing. And the reason why they saw that was not the amount of overpaving, it was the grade change. The grade change is probably 6 to 10 or 8 to 10 inches of shifted soil from one portion of the lawn to the other. Now back to your question, Bobby. Say that one more time.
I've seen all sorts of documents that have the wall designated as 2 feet. Have I misread that?
No, the zoning ordinance stipulates that the planning board can take as an expert a landscape architect, which is who designed this, and who said that landscape architect, an engineer, PE stamp, et cetera, is good as gold by our zoning ordinance. They have a registered landscape architect that designed the wall. The planning board took that as gospel, and they said it's 2 feet. I will confirm that it is 2 feet. It will not be over 2 feet because that's what they said they were going to do.
Any more questions for the Historic Preservation?
Yeah,
Please.
Mark, I had the honor of being on the Historic Preservation Commission back in 2010. Actually, like to take the seat again? No, we had some tough. We had a bunch of tough things. Just in fact, my point is, we got an expert in. We actually rewrote the 2006 to try to make applications. And but one of the things when we had this kind of view state, which is obviously, we went out and we brought in, because none of us has got a degree, none of us teachers, we're just a bunch of people who live here with very different ideas about beauty and aesthetics. Although we had, I know Burley had done the board, wrote the book on aesthetics. But we went out and got first class come over and to take a look at things. We had Bill Murtaugh come down, famous scholar. And I'm wondering, what other resources did you do to inform the very, very subjective nature of what the decision? First, there was nothing subjective. I don't believe it's subjective. Although I think those of us on the commission and others in town will certainly ask me about it. Offer subjective opinions about whether or not the town library should be changing the viewscape site. A site which has nothing else compared to. And the question is, did we bring in any more experts? No, no more than the appellant. Yeah. Well, this is tough stuff, and everybody understands what a difficult situation it is. This is a unique place in this whole world. Castine is and it's a hard place to decision, but 400 years of history. And so I'm not saying you should, anybody else should, but it is a very unique thing. I just want to make sure there wasn't some reference, some outside person, that helped you with this. None whatsoever. Okay. We relied on ourselves. Okay. And our understanding of the historic nature of the town. I'm just looking very, very carefully at the entire common. And the fact that it's historically modest. And I feel that the sort of formalization of the corner of it with stone walls and multiple trees, bushes, plantings, etc. Run counter to the gracefulness, beauty of our downtown. Does not enhance the downtown at all.
Any more questions for the historic preservation? Rock, please, just another member of this one.
I'm Brooke Penny. I'm also on the Historic Preservation Commission. I would like to speak to the walkway, which is what our subject was. And I agree that there are many brick walkways in Castine, as Nick referenced. Those brick walkways lead to buildings that are mostly white and mostly clapboard in certain architectural design. The library is not of that. And I don't think that you can compare a walkway. You can say that because there's a walkway here that's brick, that the library should have a similar walkway. I think the walkway, if it has to happen, should be appropriate to the building that it is going to. And I can't speak to anything else because we were looking at.
Other interested parties, I'm sorry, Rocket.
We've got Jeff.
Oh, sorry, please.
I just wanted to point out something that I think might be a point of confusion, maybe for us, and maybe for you, maybe for. It's that, you ask for facts and historical reference and usually when an applicant comes to us, they provide that historical reference. Some sort of data, some sort of photograph of the historic nature of the viewscape of the property that they're trying to preserve, right? And it states in there, these actions will preserve or enhance the historic and architectural nature of the building. I don't believe it's part of our business to provide that to the applicant. And during their application, we asked them to provide some background. And his reply was, to which area? I don't think that is a good answer. I don't think that provides the kind of background and reference that we're looking for to preserve that historic nature of the viewscape, of the common, of the building, etc. So to me, that was missing as a fact. That's missing in their application. And that is what I voted no.
Joe. You don't have to.
Yeah.
Well, I mean,
Mr.
But-
Chair, do you mind if I interrupt just for a second? Mary Costigan, Town Attorney. I understand that HP board members have opinions about this, but this is really not the proper venue to be. Their opinions cannot be taken into consideration by the board in making your decisions. They made a decision. They did not issue written findings. This is not sorry, my dog's barking. This is not the opportunity to kind of supplement those findings. So I just don't want this board going down a road where you're making a decision based on opinions of individual members in the audience, because I just want to make sure that you're not taking that into consideration. This is a de novo hearing. So the idea is to, narrow the scope of this review, gather facts from this proceeding. Facts I'd be looking for is it in a historic district? Is it a contributing building? Is it in the jurisdiction? When I think of a raised walkway and things that I've looked at in multiple, ordinances in my experience, a raised walkway is a boardwalk. Raised walkway is not a walkway that is flush to the ground that happens to be on fill, but it's raised because it's a boardwalk. It's actually elevated walkway. I don't know if that's the case here. It doesn't sound like it, but I haven't seen the plans, but I feel like this is getting a little out of what your task is, just gathering facts and making that decision. And if you feel that you don't have, enough information from the HP board, you don't gather it in this proceeding, you can remand it and ask them to issue a finding. I just wanted to make sure that that's the direction you're headed in.
Thank you. Brock Muir, I'm a Castine resident. I've had quite a bit of experience working with the HPC. I was gonna save this till last, but I think it's relevant just to start off with this since the last commissioner talked about, is it relevant or not? Which date are we talking about? I'd like to submit this to you all. And I guess one of the questions that always in the CHPC is what year are we talking about, what grouping? If you can see here, there are 3 different versions of the front of the library. So which one are we talking about? No idea. Nobody told me. In addition, talking about the objectives, these are facts that I think one of you was asking about. This is from the October meeting.
I'm sorry, if this is part of some official record, is that what you're reading?
It's not necessarily, I'm not sure what you mean.
Well, as Mary keeps worrying that we're gonna get off the beaten path and we need to stick
Well,
with
I
that.
think you're asking about facts, and I'm trying to provide some facts why the CHGC is rogue and made a miss call.
I don't know what you mean by rogue in this. I think
Well,
the question is, why was the decision made?
Objective.
And if you have information that would help us understand that decision and why it was made,
Yes, that's exactly where I'm going. So one of the commissioners during that meeting said, more or less, why in a million years will the library decide to add another material? That has nothing to do with the ordinance. A prejudicial statement, a bias. Number 2.
I'm sorry, Ron.
Yep.
If this is to somehow undermine the decision and the reason it was made because people came in, that doesn't help us with this here.
Okay.
Are there other interested parties who would like to speak to the appeal? Yes.
Actually, I have one more statement. And I think this is relevant. It seems to me that one of the commissioners should not be part of this conversation because of a conflict of, or at least an appearance of a conflict of interest. And I'm not sure why that commissioner is still involved in this.
Sorry, one of the members of the Board of Appeals, or
No,
we can't take that into consideration.
I don't know who does.
Are there other comments to be offered? And
I actually have a follow-up question for Jack. We have, were those part of what went to the HPC, or were there not plans included?
There was a plan. I think there's a plan and an elevation included.
Does it include the artist renderings, things like that?
Yes, yeah.
Thank you.
we're at that point where we've heard nothing, we can close the part of the meeting where we can.
Yeah, I'd like to move that we close that part of the meeting.
For a second. Discussion. All those in favor? Okay. What are the thoughts and reactions to the appeal of the decision of the Historic Preservation Commission based on what we've heard, the facts we've heard? And Mary, I assure you, we can tell the difference between fact and opinion, but I appreciate you reminding us.
I haven't heard any facts which the Historical Preservation Commission based their decision. I need more than the word usage. I don't think we have enough fact to make a decision in this case. And I would urge you to just remand this and try to get
get some more facts that we don't have enough to make a decision.
Any thoughts, ideas?
Trying to find the exhibit that I was looking, at, but I kind of inclined to agree with Mike. I don't know that there's enough in the documents from the HPC to make an informed ruling. And some of what we're talking about here is different than the plans we have. One of those walls does say it's this one. No, it's not this one. I'll find it flipping through these. But I don't know that we've got. I don't know.
If I may, we talk about, and I think we're headed down, there's a lot of talk about wild seeds and other stuff, but it looked to me like the issue is a patio and a walk. I think. And I'm wondering what the specifications are. That, you know, I mean, I want to hear heights with the colors or whatever. I'm not hearing any of that from why the Historical Preservation Commission objects to what has been presented to them. I must say, I don't have enough information to make a decision.
Justin,
Are we,
we can remain.
but are we allowed to talk to, I mean, we have these two parties, but what about the abutters? Do they have any?
They were notified.
They were notified, but is there anybody here that didn't make a statement or? Okay, but they did. Other information.
I mean, if we had to on it, I'm looking at these pictures and it doesn't look like a raised walkway. GEO says it's a 2-foot wall, but I don't know from a legal responsibility perspective if we have the ability to determine.
Well, we can also, in the absence of anything that we say, so there are 2 ways to go. One is we remand it to the Historic Preservation Commission and say, we need some substance. Substance. The other is for us to say, we have heard nothing. Ties this to a violation of the ordinance, and we can move possibly on the appeal.
Yeah.
So those are the two courses of action.
A lot of work has gone into this. Motion has gone into this. It'll be precipitous and say Articles 9 applies and walk away. I think we need to get better information. Why there's what they have bothers them about those raised walkways. Yes, but I don't think we have.
I do have a question. So this one in our appeal packets, was my question, and I know maybe this is something that Sean can clear up. On this plan that we have, it does say granite blocks 2 foot 6 inches.
What are you looking at?
I'm looking at this plan for Castine Library water flow and measurement from June 24th.
You wrote you that from the planning board.
Yeah, I think it's in the planning board packet. I just want to know, are there amended plans? Is there something that supersedes?
That was a dated plan,
There are in the
but I will have to look into that.
If you want to put that in the form of a motion, Mike?
Yeah, I'd like to make a motion that, you know, it's given the lack of specific information on this, on the quality of this decision by CHS that we remand it back to them and ask for some more specific information on how they came to turning this.
If I may, the remand would be for the board to issue written findings and conclusions that reflect the decision that they made in October. Not to go, you don't rehash it, but you're just issuing written findings as required by the ordinance.
That's what I meant to say, Mary. Thank you.
Do we have a second on Have a second discussion.
Really just like. You got a second?
We have a second. All in favor of that action, then please.
So as discussed, I want to know, is there anyone that feels strong to proceed this motion that we should rule on it? I should remand it back, but I think it's now time to discuss if we should rule on it.
Is there a party available to advise the historic commission on the specificity of what?
Sure, I don't, I think they are under themselves, they've got the knowledge and the expertise, I think it just hasn't, as Mike has pointed out. In the past, people have sought outside counsel and reason. I think that there were no reasons, there was nothing hard to go on that stuff.
But I mean, what I'm hearing though is they think there was. So I'm wondering if there is someone that can work with the commission to explain the difference or what was missing from their initial presentation.
I think we could probably in our decision, we can indicate more specifically what it is we need to go forward. All in favor of the motion on the table? I'm sorry that this prolongs things, but we thank you all for coming.
Can you clarify like what would happen?
What happened is we're gonna say, we're gonna put our meeting will align. We say. Specificity. Not obvious. I know what.
So then it comes back to, yes. It's something. Oh, just trying to understand the town. Yeah.
I think we're trying to understand, that we're going back in years. Yeah, that's better. Thank you.
Can I have a motion for adjournment?
Oh, you have to be adjourn the meeting?
We get clarification on how we or I think it's that's June.
Just got your email.
Been here. 16. Okay, yeah.